Hi there, this is Erica Marilyn. I am the founder of Perfect Legal Video, and I'm very excited. It's Friday afternoon, and we get to talk to attorney Bryan Jones. He is out of Ohio, and he is an attorney. He owns a criminal defense firm, and he is going to be shedding some light for us on the Ahmaud Arbery shooting investigation and giving us some insight to a felony murder versus complicity. And welcome, Bryan. Thank you so much for coming in today.
Thanks for having me on, Erica. It's good to see you again.
Great to see you. So if you could give us a little bit of a background, I know that this is a case that came out in February, and now it is just blowing up over the last few days because of a video that came out of the murder. So if you wouldn't mind just giving us a little bit of a background before we go into some of the definitions.
Absolutely, Erica. We've all been following the tragic case of Ahmaud Arbery, a young African-American man who was allegedly murdered by two white men in Georgia. The story really gained traction in the media after a shocking video clip was released showing the moment Mr. Arbery was intentionally and repeatedly shot by Gregory and Travis McMichael. Those two individuals have been arrested. On May 21st, the man who recorded that video, William Roddie Bryan Jr., was arrested and accused of felony murder and attempted false imprisonment for his role in that shooting.
Wow, that is amazing. I mean, most people wouldn't think that if you don't pull the trigger, you would think that you wouldn't be in trouble for anything. But this is a very interesting case. So can you tell us what is felony murder, and how can someone who didn't pull the trigger be charged with a murder?
Felony murder is a legal doctrine in some common law jurisdictions that broadens the crime of murder. When an individual kills, regardless of their intent to kill, during the commission of a dangerous or statutorily listed crime, the offender can also be charged with murder and convicted of that charge. Now, Georgia follows this felony murder doctrine, and therefore Roddie Bryan can be charged and convicted of felony murder, whether he intended to help the McMichaels or whether he did it inadvertently, unintentionally, or by mistake. Now, if you think that that sounds like an unfair and potentially problematic situation in terms of how prosecutors can choose who to charge and who to prosecute, you'd be absolutely right, Erica. Even worse, it eliminates the need for a shared and mutual mens rea or mental state among the various players and participants in a crime. What that means is that even though Mr. Bryan may have had no intention to cause Ahmaud Arbery any physical harm whatsoever, the fact that the McMichaels ultimately killed him, and if they are convicted of murder, and he is convicted or found to be responsible or played a part in the false imprisonment of Mr. Arbery, he can also be charged with and convicted of murder.
Oh my gosh, that is crazy. I mean, it was probably an unexpected day for all parties involved. I mean, Arbery was just out for a run and exercising. These people are chasing him down, and somebody happens to drive by in his path and then start videotaping the whole thing. I mean, who wakes up and thinks that that's your day? And now they're all going to be, they're all going to be charged and have been charged. I mean, you tell me what the official, the official way to say that is, but it's definitely interesting. Can you tell us a little bit more about how Ohio would handle this? Is it the same thing as Georgia?
Absolutely, Erica. All of these individuals have been charged. More precisely, they've been indicted for these crimes. Now, Ohio is different in this sense. Ohio is very progressive on this particular area of criminal justice and criminal justice reform, in the sense that Ohio has largely gotten rid of felony murder. So in Ohio, an individual must either be charged as a complicitor to murder, or they can be charged with involuntary manslaughter for the killing that occurs during the course of the commission of a felony. Now, complicity means that an individual had an intentional mental state to commit the crime of murder by either soliciting or procuring somebody to commit the crime, assisting or aiding and abetting somebody to commit the murder, conspiring with somebody to commit the murder, or causing an innocent and irresponsible person to commit the murder on their behalf. So they have to have the goal, the intent, that their victim ultimately dies. That is the complicity to murder standard in Ohio. In a situation similar to the Roddie Bryan case, if that were here in Ohio, he would likely be charged with involuntary manslaughter. Now, involuntary manslaughter is the causing of a death of another person or the unlawful termination of a person's pregnancy as the result of committing or attempting to commit a felony. So the situation arises where Mr. Bryan is accused of engaging in a false imprisonment crime in complicity with the McMichaels. Now, the McMichaels took the additional step of allegedly intentionally killing Mr. Arbery, but Mr. Bryan would be guilty in Ohio, if these facts were proven true, of involuntary manslaughter. Ohio's first-degree murder statute requires that the killing that occurs during the course of a felony must be an intentional killing in order to qualify for a first-degree murder. Instead of the felony murder rule in other jurisdictions, which only requires the intent to commit the underlying felony. The common hypothetical or anecdotal situation that we use in this situation is the robbery of the liquor store, where there's a getaway driver. Now, the robber and the getaway driver could have had a conversation before they went to the liquor store. And that conversation could have gone something like this. All right, robber, you've got a gun, but it's unloaded, or even it's a fake gun. You know, the getaway driver thinks that it's a fake gun. And you're gonna go in the store and you're gonna point the gun in the clerk's face and you're gonna say, give me the money. And if the clerk gives you any resistance, you're gonna come out and we're gonna drive away. And in the getaway driver's mind, that's the crime they're gonna commit. But in reality, the robber goes in, he's got a real gun, he shoots and kills the clerk. In Georgia, the getaway driver is responsible for murder. In Ohio, the getaway driver is responsible for involuntary manslaughter and, of course, the robbery itself.
That is a really great explanation. And, you know, it just goes to show that, like, even if you are committing a crime or planning on committing a crime, sometimes, you know, things go in a different direction. And it, you know, no crimes are worth committing, I don't think, but I mean, it just goes to show how serious it can get. But it's good to know that Ohio actually takes that progressive look and, you know, has some different standards so that when it's more serious, it's the most serious, people can get charged with a first-degree murder for that, if they intended to do it and they did it. And, you know, but if there's some gray area, it sounds like they've got some different ways of looking at it. So what would the difference be in the punishment between those crimes?
So in Ohio, murder carries the potential for a life sentence or even a death sentence, whereas involuntary manslaughter is punished as a felony of the first degree, carrying a penalty of up to 11 years.
I see. So that is a really big difference. And so when you're looking at a case like this, I mean, what are some of the gotchas, I guess, in this particular case, to where you can say, you know what, this this wasn't done right by the police, or this person is, really in this other category because of these certain circumstances?
In these sorts of circumstances, what we have to investigate is the intent of our client and the plan going into the crime itself. These are not individuals who are going to get off scot-free. In the case of my robbery hypothetical, the getaway driver is still guilty of robbery, first-degree felony, and possibly even robbery with a gun specification, which would expose that individual to up to 14 years in prison. But we really want to investigate our client's history, their taste or palate for violence, the degree of the relationship between, in the hypothetical situation, the getaway driver and the robber himself, any sort of power dynamics that there are in there. There's a wide array of potential investigative areas that we need to employ as defense attorneys in order to ensure that justice is served.
Well, that's good to know. And I know, like with any of the cases that you help people with, I mean, you really have an in-depth checklist of things to go over. And you're in court all the time handling criminal cases. So you've seen all of the different scenarios. And in fact, for anyone that has watched any of your weekly interviews, they would know that you go the extra mile in, being on the cutting edge, doing the research, making sure that you know all of the different ways that, these cases can go wrong for your client, and, really fighting for the justice that they deserve. And so I would encourage anyone that has a case of a criminal nature to, give the office of Bryan Jones a call, because they can at least give you an overview of what's happening with your case and some options. And they do a very thorough and a very educated and great job at defending you. So you couldn't have a better law firm in your corner. So Bryan, I just wanted to say, I know that we kind of went over everything here, and I just want to know, did we miss anything? Is there anything else that you thought of during this interview that you'd like to say?
I think there's a couple of things that I would like to add to this discussion. We talked about the differences between Ohio and Georgia, felony murder versus complicity. And I think our viewers would be interested to know why that's the case. Why doesn't Ohio have felony murder? And the reality is that felony murder is one of the most frequently abused charges, and most frequently abused in the sense that it's applied in a very racially disparate manner. To put a very fine point on it, minority individuals are charged with felony murder substantially more often than whites are. So that's kind of the reason for that criminal justice change. And it's a change that has been recommended broadly across all aspects of the legal system, from the American Bar Association to the National Association of Criminal Defense Lawyers, to a variety of other local and state agencies that deal in criminal justice initiatives. Second, I'd like to keep our audience informed about the power dynamics that happen in a case like this. The prosecution has now gained substantial leverage against the McMichaels, which they can put pressure on Mr. Bryan and cooperate and turn state's evidence against the McMichaels. From the defense standpoint, it's critical for Mr. Bryan's counsel to conduct their own investigation, collect witness statements, and be very prepared and ready to address the tidal wave of public opinion that is currently crashing down and will continue to crash down upon Mr. Bryan and his defense team. This case calls for experienced and mindful representation, as the elements of race and class will be key to managing the jury trial itself, the expectations of the jurors, the plea agreement, and the dynamics and potential sentence range that can result from that if this case resolves that way, and particularly the pretrial publicity and how that's going to play into jury selection should this case go to jury. Prior exposure, bias, and prejudice. Right now, everybody's got an opinion on this case. And those opinions aren't going to go away when those individuals sit in the jury box. Having skilled trial lawyer representation is exactly what Mr. Bryan needs to make sure that he doesn't end up on death row.
Well, it sounds like having the right attorney could be a matter of life and death in this situation. So, we really appreciate your analysis on this. It gives us a lot to think about. And, I'm really happy that it seems like Ohio has, really been looking at the law, making some changes to make sure that things are more fair in some of the cases we've been talking about lately. And so, I think that's fantastic. And, it's great that, you really take the initiative to go learn about these things to the best degree that you can to help your clients. And so, we appreciate you coming on here. I want to thank everybody for watching. And thank you so much, Bryan, for coming on again.
You're welcome, Erica. Thank you for having me.
All right. Thank you. Bye-bye now.